Hello, everyone. Welcome to today's webinar, Navigating the EU's Omnibus Simplification Agenda. We have quite a full agenda today, so I will dive right in. Just a little bit of orientation about the webinar platform. So the webinar slides are available to the left side of your screen, along with a few helpful links if you would like to learn more about compliance and risks and how we can help you simplify and accelerate your compliance processes. We would like this webinar to be engaging, so please send us any questions you may have, and we will aim to address them throughout the webinar. But if we don't get to answer your questions during today's session, we will follow up with you directly, so please do not hesitate to submit questions. And to submit a question, please use the Ask a Question widget on the left side of your screen. And at any time, if you're interested in having a member of our team follow up with you, don't hesitate to use Start a Conversation button at the bottom of your screen. And lastly, the webinar recording will be sent to you within 24 hours. So before we kick off the webinar, I suppose we will provide you with a bit of information about compliance and risks, especially for those of you who are joining us for the first time. So at Compliance and Risks, our mission is to help ensure global companies have the tools and the information to build safe and sustainable products in this world full of change. We are the trusted product compliance technology provider for the world's leading brands, and we have spent more than 2 decades honing the digital tools, the expertise, and the content that you need to stay ahead of the dynamic regulatory landscape and prove your product's compliance, thereby helping you protect your brands and drive your growth. And on our platform, C2P, we have a comprehensive database with over 100,000 regulations. And with global regulatory coverage and expertise across various industries, our regulatory experts are always there to assist you. Our team has quite varied experiences. We collectively speak 28 languages. And compliance and risk is also fortified by our 30 knowledge partners. So with that, let's meet our presenters for today, all of whom are part of our global regulatory compliance team. My name is Ani Nozadze, and today I'm joined by the 3 members of our wonderful team, Hannah Youngknecht, Valentina Marchetti, and Michelle Walsh. And this is our agenda for today, quite a full agenda. And again, the reason for this is that the EU has been very busy proposing changes to various regulations and directives over the past year via the so-called Omnibus packages. We will not cover all of these packages today, but we will cover quite a few of them, as you can see from this slide, and we will leave some time for the Q&A session at the end as well. So yes, as many of you might already know, the term omnibus in the EU context refers to a bundle of targeted amendments to multiple existing regulations. Like in the past year, we saw 10 omnibus packages proposed in the EU, and it spans various topics: sustainability, reporting, chemicals, data protection and AI, environmental obligations, etc. And the EU's intention really with these packages is usually to sort of simplify legislation or modernize the regulatory regime, also to reduce regulatory burden, to foster innovation, especially for smaller businesses. But because of the number of these various proposals and then revised proposals, it has really become a challenge, first of all, to track all these changes, but also to understand the impact on companies, because often these packages will either delay the compliance deadlines or introduce or extend some transitional periods, or provide for some exemptions for the SMEs, for example. And this, of course, affects the efforts that businesses are making towards compliance. So today we will try to give you a short overview of some of the changes that were proposed, and some of them were even adopted. And then we will also try to show some common themes across various packages. So with that, I will hand you over to Hannah, who will speak about Omnibus I, which relates to sustainability-focused regulations.
Thanks, Annie, for this great introduction. So yeah, as you were saying, a lot has happened in the last year, and the first omnibus package was already proposed in February last year, which kind of seems like light years away now. This package deals mostly with corporate sustainability rules, such as the CSRD, CSDDD, the Taxonomy regulation, and, which is slightly different, also the CBAM regulation. These rules were all brought in since 2020, but before many of these requirements even were able to take effect, the EU decided to roll some of them back as part of the first Omnibus, and the most prominent parts of the Omnibus are probably the CSRD and CSDDD, and that's where the most drastic cuts have happened. But the CBAM and taxonomy changes have kind of stayed a little bit more in the background, and they're more a bit kind of about fine-tuning and exemptions. I'm going to have a look at which ones of these changes have already been finalized, what they mean for companies, and what companies should pay attention to in the coming years. So one of the first regulations that was subject to simplification was the Corporate Sustainability Reporting Directive. Just put into very simple terms, this directive requires certain EU and non-EU companies to submit annual reports on their sustainability performance. And these reporting requirements in some ways were perceived as too burdensome, especially for listed SMEs that were in scope. So the EU has made quite some changes to this directive. The changes that have been made are nearly finalized now. We're just waiting for the council to formally endorse the text now. So that's going to most likely happen in March. So what we're looking at in 2026 is mostly implementation and reassessment. The changes that have been made to the CSRD can largely be summarized as timeline and content changes. So with regards to the timeline, it's really most important to note that Wave 2 companies, which are large non-public companies, now have until the financial year 2027 instead of 2025 to get ready for their reports. And then the content amendments primarily made some pretty drastic cuts to the scope of the CSRD, which has eliminated around 80 to 90% of the previous scope. So this means that all listed SMEs and all larger companies with less than 1,000 employees and 450 million net turnover are out of scope now. The CSRD still also applies to non-EU companies with a high turnover in the EU, but also here the thresholds have been raised quite significantly. Then one very important element of the CSRD overhaul are the changes to the European Sustainability Reporting Standards. These are highlighted here in yellow on the slide because this is still a work in progress. The new ESRS have significantly less data points. They have been reduced by around 60%. They focus on better and more comprehensible representation, and all voluntary data points have also been moved to a separate document. The drafts are currently with the EU Commission, and the Commission intends to make them applicable for the financial year 2027. But many companies have asked for an option for early adoption in 2026, but it's not fully clear yet if that's going to be an option or not. In addition to the ESRS, which are currently in the process of being finalized, the EU Commission is also supposed to adopt limited assurance standards until July 2027. So that's something to keep an eye on. And the Commission is no longer going to adopt sector-specific standards, which were intended for high-risk sectors such as textiles or minerals, because that's been deleted from the CSRD. But sector-specific guidance documents might still be adopted based on company demand. And then last but not least, it's also really important to look out for member state implementations of the content amendments, since member states are the ones that define penalty provisions, and they also actually have the option to change already existing CSRD implementations to exempt those Wave 1 companies that are already reporting at the moment, but that won't actually fall under the newly defined thresholds. But that's up to member states, so definitely keep an eye on this.
Yeah, thanks, Hannah, for this overview. You were talking about the new thresholds for the companies. So what does it really mean for the companies that are no longer within the scope of the CSRD? What are they supposed to do? Do they still need to follow some developments under the CSRD?
Thanks, Annie. Yeah, that's actually a really good question, because I think a lot of people assume that they don't have to pay attention anymore. But while companies that do not meet these thresholds are, of course, no longer required to submit their own report, it's still really recommended to keep an eye on CSRD developments. The Commission is first of all obliged to adopt a voluntary standard for these companies, and that's based on the currently already existing VSME standard. But in addition, companies that are out of scope might still be asked for information from larger companies in their value chain as well. There is a so-called value chain cap now, which essentially means that information requests made by larger companies are limited to the content of the new voluntary standard. But that also means that it's really important for smaller companies to know what is in this voluntary standard so they can know about their rights and responsibilities regarding information requests from larger companies.
Yeah, that's great.
So yeah, with that, I'm just going to move on to the second directive that has fallen victim to the Omnibus I, and that's the CSDDD, or also Corporate Sustainability Reporting Directive, Corporate Sustainability Due Diligence Directive, sorry. This directive essentially requires large EU and non-EU companies to implement a due diligence system to detect and address human rights and environmental violations in their own operations and across their value chains. Similar to the CSRD, also the CSDDD changes can be split into content and timeline changes. So regarding the timeline, companies now have a little bit more time to prepare for CSDDD compliance, since the compliance deadline has been pushed out to July 2029. And also member states have a bit more time to implement this until July 2028 now. With regard to the content, Omnibus has also changed what companies are actually required to conduct due diligence, and that's only the largest companies now with more than 5,000 employees and 1.5 billion net turnover. Same as the CSRD, the CSDDD also continues to apply to non-EU companies, but only to those with EU turnover of at least 1.5 billion euro. Then one very highly debated issue over the last year was the way companies are obliged to carry out due diligence. That's based on Article 8 of the directive, and the adopted text now contains a risk-based approach, but with a strong focus on reasonably and publicly available information, and also focus on impacts involving direct business partners, which by many has actually been criticized as being a little bit too shallow. Then two important components of the CSDDD that have actually been deleted entirely are the requirements for companies to adopt and implement climate transition plans, and also the harmonized liability requirement that was directed at member states. And then just kind of looking ahead a little bit into the next year, one important thing to look out for is the adoption of CSDDD guidelines, which will hopefully provide some practical examples also for specific sectors on how to conduct due diligence. And the first set of guidelines must be made available by July 2027. So we're hopefully going to see some drafts this year. So moving on, unfortunately, very quickly, of course, to the third regulation that was under scrutiny as part of Omnibus I, and that's the Taxonomy regulation. The Taxonomy regulation was already adopted in 2020, so that's already a few years ago. And it basically sets out a standardized classification system for what is considered an environmentally sustainable economic activity. It also requires companies and investors to disclose how their activities are aligned with the taxonomy criteria. And these screening criteria that determine which activities are considered sustainable are set out in delegated acts. As part of the first omnibus package, the EU decided to simplify some of these delegated acts. So there is no direct changes to the taxonomy regulation itself. And the simplification has already been published in the journal at the start of January. So this amendment is basically done and dusted for now. One of the main changes that has been made here concerns the materiality of activities. So in their reports, both financial and non-financial companies can omit activities that are not material to their business. For non-financial companies, activities that are considered not material are those that stay below the threshold of 10% of the capital expenditure, operational expenditure, or turnover. And the materiality, that's important to note as well, it has to be assessed for each KPI separately, and companies also still need to indicate in their report what percentage of the CapEx, OpEx, or turnover was admitted. So they still need to disclose on this, but they don't need to assess it properly anymore. And for companies that consider OpEx as not material at all, this can actually be omitted entirely now. So this is probably quite a big change for companies. Then on top of this, the Commission has also streamlined and reduced the reporting templates, and it's made some changes to the screening criteria themselves, in particular in relation to pollution, with regards to the assessment of ozone depleting substances and chemicals. And then when we look at the timeline, these new rules are applicable from 1st of January 2026. But for the financial year 2025, which is the year that companies are reporting for at the moment, companies can actually choose between applying the new or old rules. And we also know already that there is more changes on the horizon since the Commission already launched a call for evidence in November with the goal to simplify the technical screening criteria and the do no significant harm criteria of the delegated acts. So there is more coming in the next few months, most likely. Then moving on to the fourth important pillar of the first omnibus package, and that concerns the amendments to the carbon border adjustment mechanism. So for anyone who's not super familiar with this quite technical regulation, the CBAM was introduced in 2023 to complement the EU emission trading system. The EU emission trading system focuses on energy-intensive sectors in the EU, and companies active in these sectors get a certain number of CO2 allowances, and they can then buy and trade surplus allowances. This system might, however, lead to carbon leakage, which basically means that carbon-intensive production is relocated to outside the EU and products are being imported instead of produced here. The CBAM is basically supposed to address this carbon leakage by putting a price on imported high-risk products that mirrors the ETS allowance price. And CBAM has already started with a transitional reporting phase between 2023 and 2025, but the full obligations have now started from January 2026. But as kind of seems to be a little bit the trend here at the moment, before CBAM even commenced properly, the EU decided to make certain changes to the CBAM system. These changes are also already finalized. They've been published in October in the regulation that is indicated here on the slide. Just for the sake of time, because we have so many things to go through today, I won't go into every single detail here. We actually have some really good blogs on our website that explain the new timelines and the new requirements in detail. So I'm just going to give a very high-level overview here. In terms of the timeline, the commencement date for the sale of certificates was postponed from January 2026 to February 2027. There's also a new grace period for the application of authorized CBAM declarants, and declarants now have a few more months to prepare their CBAM reports for the previous year. So all of this is basically trying to give companies a little bit of breathing space. Then other changes concern the way exemptions are calculated, which is now shifted from calculating every single consignment to an annual calculation. And CBAM declarants now also have a little bit more flexibility throughout the year in terms of what percentages of emissions must be covered by certificates at the end of each quarter, even though it's, of course, important to note that at the end of the full CBAM year, coverage must still be at 100%.
Yeah, that's great. Lots of things to think about for manufacturers, for sure. And thanks for the summary about the CBAM in the first omnibus. But outside of omnibus, I think there have been some developments, right? So what are other what is the other important information that companies importing CBAM products should be aware of?
Thanks, Anya. That's actually a really important question because there are some very important developments happening at the moment that were proposed after the omnibus was already finalized with regards to CBAM. So in December, the EU issued a CBAM package that consists of multiple parts. So firstly, the Commission has issued 8 CBAM implementing acts that contain all the details that declarants need to know about the functioning of the CBAM, for example, calculating emissions, calculating certificate prices, and all these kind of things. So that's basically your kind of CBAM instruction manual. And then on top of that, there are 2 draft regulations that actually propose further changes to the CBAM itself. And one of those proposals suggests extending the CBAM scope to around 180 downstream products. And we have heard from customers recently that that's actually favored by a lot of EU companies. And the reason for that is that in its current form, CBAM only applies to basic material goods like steel and iron. But that puts a lot of pressure on EU manufacturers of downstream products that contain these basic materials because they basically have to pay twice. And they're struggling to compete with imports, and that might lead some manufacturers to move their production to outside the EU, leading to more carbon leakage. So to prevent this, CBAM should now be extended to downstream products. And then there's also a second amendment that contains measures to prevent circumvention of the CBAM obligations. So there is loads to keep an eye out for in 2026.
Thanks, Anna. Thanks very much. We will move to Omnibus IV now, which encompasses quite a few sectors. So, Michelle, tell us, why is the EU Commission proposing this Omnibus package, and how is it important for companies?
Thanks, Annie. So Omnibus 4, it's basically targeting overlapping, excessive, outdated product rules. So this is really about product legislation. And there are 4 parts to it. First part, it creates a new category of companies called small to mid-cap companies. And this allows certain companies to avail of exemptions to requirements in certain EU product laws. There's a move towards digitalization over paper format as well. It's the second part to it. The third part is the use of common specifications, which is an alternative to harmonized standards. And the fourth part looks at the batteries regulation, how to ease some of the due diligence requirements for companies. Okay, so I'll jump into it. So the Omnibus 4 small caps. So basically the proposal is to create this new category of companies. At the moment, in a lot of EU laws, there is an exemption from certain requirements for small to medium-sized companies, which are companies that have less than 250 employees and a turnover of less than 50 million. What's happening is that in the EU, this is actually, is looked at, there's a lot of companies that are just over this threshold, and they are actually being treated like really, really big, giant global corporations. So they're getting hit with a lot of very burdensome requirements. So the proposal is that for small mid-cap companies, they will be exempted from certain requirements in EU laws. Now, the exact definition of this small mid-cap company is not agreed as yet. The Commission has said it should be companies with less than 750 employees with a max turnover of less than 150 million. The EU Council thinks it should be a bit more, so it should be less than 1,000 employees with a higher turnover of less than 200 million. The Parliament still hasn't decided, so we're waiting for the exact definition. But it will exempt certain companies from certain requirements. So, for example, in the EU batteries regulation, there's an exemption for small to medium-sized companies from due diligence requirements. This is a really difficult requirement. It requires economic operators to publish a due diligence policy on their websites. They need to basically look at all their supply chains and check the critical raw materials that they use in the batteries, and check for social and all the environmental risks, and publish this report on their website. So the suggestion, the proposal is that the small mid-cap companies would also be exempted from this requirement. Also, it proposes that economic operators, at the moment, this policy must be published every year on the website, and they want to move it to every 3 years because it's a very, very burdensome requirement for many companies. Another major regulation that would be affected by this new company category is the GDPR, your General Data Protection Regulation. At the moment, there is exemptions for certain record-keeping requirements for small to medium-sized companies. The proposal is that companies with less than 750 employees would be exempted from maintaining certain data processing activities. So they still would need, though, to keep records on high risk, just alleviating some of the burdensome requirements for certain companies. The next one is, the proposal is to move to digitalization, and this is basically removing mandatory paper requirements in certain laws and allowing companies to provide this information in digital format. It's quite amazing that a lot of member states still require the submission of conformity and technical documentation in paper format. So it's moving away from that. That's felt that it's very outdated. It's very, very costly for companies, as well as instruction manuals may be provided in electronic format, except for safety instructions to consumers, because they don't think, I think consumers need some kind of paper format to check. They don't want to be going onto their smartphones to check safety information. So that's excluded. But this is an amendment to 20 different laws contained in regulations directives. So I think it'll save a lot of costs for a lot of companies. The third part to this is common specifications. So in the EU, under directives and regulations for manufacturers, to show a presumption of conformity to essential requirements in this. They use harmonized standards. This is great, but sometimes the harmonized standards don't exist. They're not available. They're insufficient. So their manufacturers are really left with scratching their heads on what to do. Also, sometimes these standards take years and years and years basically to be developed. So there is a kind of compliance gap here, which is really difficult and time consuming and a massive headache for companies. So again, this is an amendment to 20 different laws. So it affects product legislation such as the ROS directive, the low voltage equipment directive, the EMC directive, radio equipment directive. And what it suggests is that where there's an absence of harmonized standards as an alternative, the EU Commission will have common specifications which can be used to demonstrate a presumption of conformity to the essential requirements in these product laws. Now, the exact format of the common specification hasn't been defined. We're not sure exactly how this is going to look, but the idea that there will be an alternative, especially where there is a lack of harmonized standards, is really good news, because we do get questions on this. What should I do? There's no harmonized standard. And to fill this gap, these common specifications will be welcomed by a lot of manufacturers. The fourth part is looking at the batteries regulation. Again, this due diligence obligation has been pretty much a nightmare for battery manufacturers. When we speak to our clients, they basically were saying it was such a difficult requirement that a lot of companies just weren't going to be ready on time. So the Commission has actually approved this regulation, and it's a stop the clock regulation, which means that the due diligence obligations, which were previously due on August 2025, are now pushed forward to August 2027. One of the main problems was that the guidelines that the Commission was supposed to publish to help companies weren't yet available. So even the Commission is finding this requirement very, very difficult to comply with. So the guidelines were supposed to be published in February of last year, but now they're expected in July of 2026. So again, I think sometimes the EU legislation can be a bit too ambitious, and without the proper guidelines for companies, these requirements just can't be met by manufacturers.
Yeah, definitely. And that's what we've heard from a lot of our customers, and a lot of, our in-person events that we talk to them, is often you really need to look at some of the guidelines or FAQ documents or, similar type of clarifying documents, I suppose, because sometimes regulations just are a bit too much to digest. But thanks for that, Michelle. It was really good. I know that there are some more simplification initiatives, and maybe you could quickly cover that as well. So what is EU Commission working on further?
There's a lot happening, yes. An interesting one is actually there's a look at a better regulation framework. There's just been a consultation on that in the EU, and this is actually looking at how EU law, like the actual process of how EU law is passed, and how difficult and time-consuming this is. And we're expecting a communication from the Commission in Q2 of this year, so very soon. And it's going to look at how to streamline the process of the adoption of EU law, to have better targeted stakeholder consultations. And I think, again, just to make the process a lot more easy. So again, simplification is definitely the key to making business a lot easier in the EU. I'm going to see it not just in laws, but also in the whole system of the EU itself.
Yeah, that's great. Thanks so much, Michelle. Let's move on to chemicals and Omnibus 6 now. Valentina.
Thanks, Annie. So yes, now let's dive into Omnibus 6. That is the EU chemicals package released in July 2025, together with the action plan for the chemicals industry. This package focuses on two main areas. First, it aims to simplify the CLP rules for the labeling and packaging of chemicals. And second, it introduces additional simplification for specific sectors, in particular fertilizers and cosmetics. And today I'm going to cover specifically the CLP and the cosmetics sections. So Omnibus 6 is split into two parts. The first part is already in force, as this was treated as a matter of urgency. is the so-called stop-the-clock legislation for chemicals. And this poses certain specific CLP obligation, like new label formatting and advertising rules, moving their deadline to January 2028. These obligations were originally due to apply between this July and next January. And this pause follows a reality check carried out by last May, where both industry and authorities flagged that these new specific requirements under the 2024 revision of CLP were really difficult to implement. So this first step is about providing breathing space while the permanent rules are finalized. And these are treated in the second part of Omnibus 6, that is where the core changes are. This is still a work in progress. The Commission presented its proposal in July, and the Council agreed its position last November. And currently, the Parliament is finalizing its own position. This will lead into the negotiation phase between the institutions. And this second part includes permanent amendments to the CLP, the cosmetic and the fertilizing product regulations. As we go through the details, you will see that while the Council generally supports the Commission's approach, its mandates introduce more specific deviation and protective measures. So I will start with the key change to the CLP. The proposed change here are really about finding a better balance within transparency and practical flexibility. As I mentioned, the Council generally supports the Commission approach, but introduce a more protective framework in certain areas. First point is regarding label formatting. So the 2024 CLP revision introduced very rigid rules for fonts, colors, and layout of labels. And Omnibus 6 replaced this with a simple principle. Basically, labels must be easily readable. And the Council mandates clarify this requirement, specifically ensuring that font size remains appropriate relative to the size of the label. Second point, label update deadlines. Under the current rules, label must be updated within a fixed 6-month period, following a classification change introducing new or more severe hazard classifications. The proposal replaced these with a more flexible standard, so labels should be updated without undue delay. The Council supports this approach, but add guidance indicating that updates should generally not take longer than 12 months. Third point, advertising and distance sales. So under the current rules, all advertisements and online offers had to include full hazard information. This proposal limits these only to products sold to the general public. And for advertisements, instead of repeating every hazard details, they should simply encourage users to read the label. The Council in its positions clarified that distance sales rules still apply whenever an online offer is accessible to consumers, even if the product is primarily intended for professional users. Beyond these main points, the other proposals are adding a digital contact like an email or website to supplier details, also allowing extra suppliers' contacts to appear only on the digital label, thereby expanding the use of digital labeling that has been included with the last revision of CLP. And these align with the broader digital by default approach that Michelle was mentioning before. And finally, also simplified rules for small packaging. Now let's move to the cosmetics part. So here the Commission proposal was broadly seen as positive, but the Council position has raised some concern within industry. The most important topic is the CMR framework. So substances that are classified as carcinogenic, mutagenic, or reprotoxic under the CLP regulation remain banned unless a derogation is granted, and this principle remains unchanged. But the Commission proposal aims to clarify and improve how the derogation framework works in practice in order to avoid automatic bans on ingredients that can be safely used in cosmetics despite their hazard classification under CLP. And to support this, the Commission introduced a more detailed procedure, including consideration of the route of exposure, and also clear treatment of natural complex substances such as essential oils that can contain some classified components. In its mandate, the Council has taken a more hazard-based approach, so some elements of the Commission proposal, including route of exposure considerations, were removed. And as a result of these, industry stakeholders have expressed concern that derogation may remain really difficult to obtain in practice, in particular due to the requirement to show that no suitable alternative exists. Another key area of discussion is around deadlines for phasing out cosmetics products containing banned or restricted substances. The Commission proposed a 12-month adaptation period, but the Council shortened these to 6 months for placing products on the market and 12 months for sales, which is, however, still longer than the deadlines under the current rules. Other point, ingredient inclusion. The proposal introduced a clear procedure for adding new colorants, preservative, and UV filters to the positive list under the regulation. And this is intended to make the process faster, more predictable, and facilitate the use of new ingredients. Other point, nanomaterials. So there is a specific requirement to notify nanomaterials, and the Commission proposed removing this requirement on the basis that it duplicates the general product notification obligation. But the Council decided to retain the requirement, adjusting the timing so that now notification should be submitted before the product is placed on the market rather than 6 months in advance.
Yeah, there's lots going on between the Commission and the Council, as usual, a lot of diverging opinions. Thanks, Valentina, for this summary. And we know the chemicals are also addressed under another package, another omnibus package, the environment package, which we will cover later. So can you just give us a quick preview of the chemicals-related proposals that are concerned in there?
Yeah, sure. So one of the key proposals in Omnibus 8 is the repeal of the SKIP database. So SKIP was introduced under the Waste Framework Directive in 2021 and requires companies to notify the European Chemical Agency when articles placed on the EU market contain substances of very high concern. In practice, however, the reporting burden has been significant and largely overlaps with other requirements under REACH. So as part of this simplification phase, the Commission is proposing to repeal the SKIP database, also because we expect that its function will be replaced by other digital tools, particularly the digital product passport.
Yeah, that's great. Yeah. Thanks, Valentina. I'll move on now to a quick overview of the digital omnibus and the omnibus on AI. Which is sort of closer to my heart. So yeah, in November 2025, the EU Commission presented 2 packages of proposed amendments to certain EU digital laws. And the first package, the name of which is Digital Omnibus, proposes changes to the GDPR, the e-Privacy Directive, the Data Act, and a few other laws. And then the second package, which is called Digital Omnibus on AI, focuses on the AI Act. So just to quickly review some of the changes that are proposed under each package, I'll go through all of this, but also due to time constraints today, because we're covering quite a lot, as you can see, I probably won't be able to address everything in detail, but there are 2 very good blog posts published on our website on Digital Omnibus and the Omnibus on AI. So please do explore our website, specifically the blog section. And if this is something of interest to you, you can find them there. Just to mention a few changes proposed to the GDPR. So there's a clarification proposed to the definition of personal data based on some of the recent court cases as well. And there are a few new additional definitions there as well. There's also 2 additional derogations from Article 9, which relates to processing of special categories of personal data. And some other changes also include provisions on abusive data subject access requests. There are some changes also proposed to ease the transparency requirements when the personal data is collected directly from the individuals, the data subjects. There are slight modifications to the rules for automated individual decision-making, etc. But one key proposed change that is probably a very welcome change relates to data breach reporting. So this is really a cross-cutting proposal, and this aims essentially to establish a common portal for reporting all incidents under not only the GDPR, but also the NIS2 directive, the Digital Operations Resilience Act, the DORA, and the Critical Entities Resilience Directive. So this should hopefully really make it easier for organizations to report incidents. The maximum period for reporting data breaches and incidents is also proposed to change from the current 72 hours to 96 hours. And also the reporting threshold is also proposed to be raised. And it will be data breaches likely to result in a high risk to the rights and freedoms of individuals. And the European Data Protection Board, the EDPB, is also tasked to draft a list of circumstances when the breach is likely to result in a high risk. So this is good news. There's also going to be a common template drafted by the EDPB for notifying these breaches. So that's really good news. The proposal also requires the EDPB to prepare a list of processing operations that are subject to the obligation of data protection impact assessments, the DPIAs, and also those processing operations that are not, that do not require the DPIAs. So currently this is done by the member state supervisory authorities. So again, this proposed change aims to bring some more consistency across the EU. The board will also prepare a proposal for a common template to do these data protection impact assessments, and also a common methodology for conducting them. So this should really help out companies in meeting this requirement under the GDPR. So the Digital Omnibus also tries to address challenges around cookie banners and consent fatigue that we are all familiar with. So the EU Commission proposes a new article into the GDPR that will set out consent requirements for storing and accessing personal data on terminal equipment of individuals, which is currently dealt under the e-privacy directive. So users will be given the ability to refuse non-essential cookies with a single click. And if this request for consent is declined by a person or by a user, then a new request for consent for the same purpose may only be made after at least 6 months. And, we already heard from Michelle regarding the changes proposed in terms of removing certain record-keeping obligations from the GDPR for small and mid-cap enterprises, and we'll see how that will also play out once that is finalized. And then moving on to Digital Omnibus on AI, it also proposes quite a few important changes. One is the adjustment of application dates for high-risk AI systems. And this is addressing industry concerns about the delays in the creation of necessary standards. And I think this was, again, something that Michelle mentioned as well, because I think the companies really want to know and really want to have some sort of set of standards to be able to comply with certain obligations. So that's how this came about. And then the proposal also extends certain simplified obligations of the AI Act from SMEs to small mid-cap companies, so the SMCs, for example, simplified technical documentation. And the AI office is also granted exclusive supervision and enforcement competence for those AI systems that are built on general purpose AI models, and also for AI embedded in very large online platforms, the VLOPs and search engines. And the aim is also to broaden the use of AI regulatory sandboxes and overall real-world testing. And the proposal aims to set up an EU-level regulatory sandbox from 2028. And of course, there's a lot of detail to all these proposed changes. And if this is really a topic of your interest, I would honestly encourage you to watch back a webinar presented by our colleagues just about a month ago, which provides a more in-depth discussion of AI regulatory updates, which concern not only EU, but other jurisdictions as well.
Thanks, Annie. That was super interesting. And I actually see a question here in the chat box that I guess doesn't only concern companies, but it kind of concerns us as consumers as well. So about the proposed article in the GDPR under the Digital Omnibus that kind of concerns processing of personal data for AI model training. Can you kind of elaborate a little bit on the details of that?
Yeah. So this is Article 88C that is proposed, and it did cause some controversy. So essentially, this provision states that processing personal data for AI model training is a legitimate interest under Article 6 of the GDPR. But there are exceptions to this. So this is not a blanket provision. So these are when, for example, an EU or the member state law explicitly requires consent. So then you cannot rely on the legitimate interest. And also when the company's legitimate interests are overridden by the interests and fundamental rights of individuals, especially in case of children. So of course, EU does not want to hinder innovation that it has been brought by the AI, but also the balancing test is really crucial. So I suppose it remains to be seen now how this, what shape this provision will take after going through the legislative process.
Thanks, Annie. Yeah, that's indeed something interesting to watch in the coming months. Thanks for summarizing everything regarding AI and data protection. I'm going to move on to a completely different topic now. I know we're covering a lot of very different topics in this webinar. So the next one is the environmental omnibus. That's Omnibus 8. We already talked a little bit about it earlier with regards to chemicals. The environmental legislation package was proposed in December last year, so quite late, and it concerns a pretty broad range of issues that relates to chemicals, as we already talked about, industrial emissions, circular economy, environmental assessments, so there's lots in this. Michelle is going to give you a brief update on the waste management aspects of this, but I'm going to focus a little bit more on the industrial emission side of things now. So the first part of this package focuses on environmental impact assessments and environmental management systems. So with regards to EIAs, the main goal of this is essentially to speed things up and to be able to realize large projects faster. The package concerns impact assessments that are conducted under 4 core environmental assessment regulations. That also includes the Water Framework and the Birds and Habitats Directive. And member states would essentially be obliged to shorten their assessment periods and also create a single point of contact for all issues related to this. While I guess a broad range of products are likely going to be benefiting from this, the proposal mentions in particular circular economy projects like recycling plants and also AI factories. Then a second part of this focuses on environmental management systems. So these systems are mandatory under the amendment to the Industrial Emissions Directive, and companies are essentially required to implement a system to make their installations more efficient in terms of energy use, water use, and waste prevention, and so on. The environmental legislation package proposes to reduce the obligations quite significantly. So, for example, by allowing companies to consolidate systems for several plants in the same country, and also removing some of the obligations around chemical inventories and indicative transformation plans as well. The obligation to implement an EMS is also proposed to be pushed out from currently 2027 to now 2030. With that, over to Michelle, who's going to talk about EPR.
Great, thanks, Hannah. So basically, as part of Omnibus 8, we also have a proposed suspension of the requirement to appoint an authorised representative for extended producer responsibility schemes in the EU. So at the moment, we have extended producer responsibility for packaging, batteries and single-use plastics. And so basically, if you don't have a company presence in one member state and you're selling another, you need to appoint an authorized representative. So the proposal is to suspend this requirement for EU-based companies for these EPR schemes for packaging, batteries and single-use plastics until the 1st of January 2035. So the result is basically if you're based in one member state and you sell in another, so if you're based in Belgium, for example, and you're selling into Spain, you can choose to either appoint an authorized representative in Spain, or you can take care of the requirements yourself. So you could do the reporting and the registration from your company the member state that you're based in. So this will actually save a lot of money. At the moment, producers have to appoint an authorized representative every single member state where they sell into, where they place their products on the market. So it can be a huge cost. If you're based outside the EU and you're selling into the EU, the rules do not change. If you still will need to appoint an authorized representative in the member states unless you have a physical presence there already. There's a lot of debate about this one. I'm not 100% sure how this is going to work, because it's going to be a nightmare for market surveillance authorities, for enforcement authorities, having, I suppose, these requirements being reporting, registration from different types of different member states. I think this is going to be a bit of a headache for the enforcement authority. So there is a lot of debate about this, whether this is really going to work well in practice. And so we're keeping our eye on this proposal for the moment. So that's it. I'm going to hand you back to Annie.
Thanks, Michelle. I think we can perhaps wrap up with some key takeaways and then move on to a few questions. I'm just going to ask each of you to just give one key takeaway about the things that you spoke about. So Hannah, I'll start with you about Omnibus 1.
Yeah, sure. So I guess my key takeaway around Omnibus 1 is that the situation regarding corporate sustainability reporting and due diligence is likely going to stabilize a little bit in 2026, because these simplifications of the main regulations have largely been finalized now. But it's now absolutely crucial for companies to reassess their applicability and to define their strategy for the coming years, also keeping in mind that the postponed regulations simply give you a little bit more time to act and to prepare, but not more time to wait, especially since investors and other stakeholders will keep asking for the data in the meantime anyway. And then also the delay introduction of the CSRD and the CSDDD are just really small snapshots, because a lot of other EU regulations are actually staying on track. For example, the ban on products made with forced labor is staying fully on track so far. And also a lot of other corporate sustainability regulations, both in Asia and Latin America and other parts of the world, are moving forward, and they're creating new compliance challenges as well. So I think one main key takeaway here is also to kind of zoom out and not forget about other markets as well.
Yeah, good suggestions. Thanks, Hannah. Michelle, over to you.
Hi, yes, this is in the same vein as Hannah there. I mean, simplification is great for cutting red tape, reducing costs, and I suppose modernizing really outdated rules, but be very careful. A lot of the requirements, these heavy requirements, okay, they might be delayed, but they're still there. It's just how to make business a bit more efficient. They don't remove requirements in a lot of sustainability laws, and there's a lot of them are coming into force this year, or their date of applications are this year. We have the Right to Repair Directive is going to apply from August this year. We've got the packaging regulation, greenwashing directive as well. They're all coming into force and applying in the member states in August of this year. So again, just to be careful, these omnibuses are great, but they're only relieving certain requirements, and a lot of these really heavy requirements do remain. So just to be careful, I think it's the key message.
Good tip. Great. Thanks, Michelle. I'll come to Valentina next.
Yeah, so for Omnibus 6, one key takeaway for CLP is that we have to keep in mind that the time applies to labels, but not to hazards, because the stop the clock means companies don't need to worry about revising label formatting right now, as we wait for the permanent simplification rules. However, this pause doesn't affect other requirements, such as new hazard classes, which continue to advance. While for cosmetics, the risk versus hazard debate continues. We have seen that the Commission approach face a sort of pushback from the Council toward a stricter hazard-based default. So we're now waiting for the Parliament position to see, and the final negotiation to see if the safe use exemption will survive for cosmetics.
Thanks, Valentina. Yeah, and for myself as well, yeah, I think there's lots of good news in the Digital Omnibus in terms of kind of efforts towards harmonization. But also, I think one thing to keep in mind that I think all of us have mentioned is like delaying application dates or timelines does not really mean like more time to relax and not think about these things. I think it's just more time to act and to prepare even better. So implement those policies that you need to do. And one final overarching key takeaway, I think, from all of this is just keep on top of the legislative developments, do your horizon scanning and regulatory tracking, and make use of these tools that exist, thankfully, these days, the likes of C2P, where you can actually get notified when there's something coming down the line or it's about to be adopted or it enters into force. And, you know, it's like today we focused on EU, right? But this, like, it doesn't end here, of course. And there are a lot of other jurisdictions that are becoming active, especially for human rights, due diligence obligations, sustainability laws, chemicals, of course, is a huge thing, and, you know, other product safety laws as well. So I think if you are a company that sells or sources from markets such as, I don't know, Asia, like Thailand, South Korea, Indonesia, or South America, for example, has become active about sustainability as well, you do really need to keep up to date. So that's probably one final takeaway here as well. I will now open up the floor for some questions, and we do have quite a few questions in the chat, and I'll just maybe select one or two because we have a few minutes left. Okay, yeah, so there's one on CSRD. So for a large manufacturer that was part of the first CSRD wave, but now doesn't fall under the new CSRD thresholds, can we stop preparing for CSRD compliance now? Hannah, you'll probably take this one.
Yeah, sure. I think I probably mentioned this very briefly earlier, but since we're kind of rushing a little bit through everything, I'm just going to go back to what I mentioned earlier. So this is actually a little bit tricky, and the answer really depends on what EU member state your company is based in and whether or not this member state makes use of the option to exempt Wave 1 companies that are no longer in scope. So it's correct that the CSRD thresholds are much higher now, and many of the previous Wave 1 companies will actually no longer be in scope, but member states eventually have to align their national laws with these new thresholds. And in the meantime, it's up to the member state if they want to exempt Wave 1 companies that are currently in scope right away. If they don't do this, it will lead to some companies having to report for 1 or 2 years, and then they can stop reporting once the new thresholds kick in. And I'm assuming the EU is giving member states this option to not interrupt kind of ongoing processes like auditing processes and these types of things. But this, of course, kind of makes it really important for companies to watch the member state implementations very closely as well, to kind of see like what their like specific timeline in the member state is.
Thanks so much. Maybe one more question. So there was a question that I think a lot of customers usually ask this question, is like, how likely is it that a certain proposal will be accepted or not? And in this case, one of our attendees was asking about the authorized representative. Michelle, any thoughts? I know it's always very hard to predict whether something will be accepted or not, and whether it will go through the EU legislative process, but if you have any thoughts.
This one, I think the proposals need a bit more work, to be honest. It doesn't make sense from an enforcement or market surveillance, side of it, how they're going to monitor this. So I think there is merit in being able to choose whether you appoint an authorized representative or not. I think companies sometimes see it's basically a waste of money because they can do this themselves. It will be a choice for companies. You don't have to appoint one, or you can do it yourself. I do think that these proposals need a bit more work. I think there should be some kind of harmonization, maybe, that if you're going to do it yourself, how can these enforcement authorities basically contact you? Maybe some kind of database, that would be the ideal scenario. But my view is that they need a little bit more work for this to actually work in practice. So
that's great. That's great. Yeah. So we'll see how it goes as well. Thanks, Michelle. Thanks a lot. We might take one more, and then I think we'll thank everyone for their attention. One question was about if my company is no longer in scope of CBAM due to de minimis threshold, do we still have to report something, or are there registration obligations? Hannah, I think you will be able to.
Yeah, sure. So like the short answer to this is no, but I think it's very important to note that the registration obligations, they aren't based retrospectively, but they're kind of based on what you expect you're going to import throughout the year. So if your expectation is that you're going to get over these thresholds of 50 tons, then you have to register in advance. If your expectation is that you're not going to get over the threshold, you don't have to register. But yeah, like just kind of note that it's kind of more like a kind of looking into the future sort of requirement.
That's great. Thanks, Hannah. Thanks a lot. And we're at time. Thanks so much for sticking with us today and for tuning in and for all your questions. Like I said, we will come back to you with the answers to the questions that we weren't able to answer now. We really hope that you found today's presentation helpful. We look forward to seeing you in our upcoming webinars. You can check out a lot of resources on our website as well, under the resources section, and you can stay updated. You can see our white papers, blogs, and webinars there. So we definitely have plenty of upcoming content. So thanks very much. Thank you. Bye.